So welcome back to Contract B, and this is the part 2 video for Equitable Estoppel. And if you recall, we are up to element 2, which is inducement. So without further ado, here we go. The second element is inducement. And here we have the starting point of the tentacles of unconscionable conduct finding their way into the requirements for equitable estoppel. So the defendant has to actually play a part in the plaintiff adopting this assumption that ultimately will cause them some kind of detriment if the defendant is allowed to resile from the assumption. The inducement can be by words, by conduct. It can be by silence if there is an attempt to assert a legal relation different to that which was assumed by the other party to the knowledge of the silent party. So pretty much like we've been discussing in mistaken misrepresentation, if your silence is going to lead that other party to engage in conduct to their detriment, to adopt their erroneous assumption, and you can't go ahead and try and set up someone else for a case of equitable estoppel. It's just not going to work. I keep saying the cases in Contract B are great. This is just another one of them. In SkyWest and the Commonwealth, this was just one of a number of cases that evolved from some circumstances where the Commonwealth needed to have some surveillance conducted in the top end of Australia for illegal arrivals to Australia and other naughtiness that might go on. The surveillance was to be done by air, and SkyWest had had a previous contract with the Commonwealth. That contract was not renewed. The Commonwealth then put the contract out to tender and secured Aman Aviation, and things went spectacularly wrong with the Aman contractor. That contract was promptly terminated by the Commonwealth, and that involved a whole host of other entertaining facts, which we'll go into when we discuss termination later on down the track in Contract B. But after they had finished dealing with Aman, they put the contract out to tender again. SkyWest put in a tender submission. And their tender submission, they knew that they had to fit out 3 aircraft to complete the surveillance that the Commonwealth required. However, in their tender documents, the price that they arrived at for the Commonwealth so that they could actually secure the tender was very low. In fact, it was lower than what it was going to cost them to modify the aircraft and so on to complete the job. So in their negotiations with the Commonwealth, the SkyWest officers kind of dropped into the conversations at various points a reference to this equalisation that they believed the Commonwealth was going to engage in. And they made sure that the Commonwealth officers were aware of their discussions about equalisation. The Commonwealth officers had no clue what the SkyWest officers meant by equalisation, but of course the SkyWest officers had devised this term to sound deliberately quite vague, but what they meant was the Commonwealth was going to pay the diff. The Commonwealth was going to actually foot the bill for the modification of the aircraft to get them up to par so that they wouldn't be making a loss on the transaction. Now, later on when SkyWest secured the contract, they tried to enforce this understanding, and of course they wanted to hold the Commonwealth to these so-called agreements about equalisation that occurred in the course of the negotiations. And the court said, no, what you can't do in equitable estoppel is you cannot set someone else up to document them in a fashion that will expose them to an action for equitable estoppel. The inducement has to be by the defendant to the plaintiff. And in this case, the court said all the inducement has been from the plaintiff to the defendant. So no equitable estoppel there, obviously. And that is element 2. Okay, so element 3 is reliance. And obviously for the plaintiff to rely on whatever assumption it is that they have adopted at the inducement of the defendant has to be reasonable. Okay, so remember back to the Ostertel case. In that particular case, it wasn't going to be reasonable for Franklin's to rely on the assumption that a lease actually would eventuate because a fairly major term, that is, the rent for the significant additional floor space, had not been agreed. And it specifically hadn't been agreed because Franklin's failed to mention it in the hope that it wouldn't crop up. So in those kinds of situations, commercial hard-nosed entities, the court's going to have a real hard look at whether or not the reliance was reasonable. Now you'll see in the text, it does go on to discuss the whole issue of whether or not negotiating for a contract on a subject to contract basis, that is, as you know from contract A, you make it very clear to the other party that you're not going to consider yourself legally bound until you actually have the written document there and signed by the parties. The question is whether something like that is going to prevent an equitable estoppel from arising because the other party is on notice that the defendant will consider themselves quite free to walk away unless that contract is signed. Certainly on Brennan's view from the Walton Stores case, where he seems to think that this element of assumption, the first element, has 2 limbs to it, and the second limb requires the plaintiff to turn their mind to whether or not the defendant can actually withdraw from the assumption that they've induced. On that kind of a view, we'll then know, obviously, if the defendant has made it clear that they're negotiating subject to contract, it's not going to be reasonable for the plaintiff to rely on whatever assumption has been induced. The text does talk about a broader view and, a little bit more permissive where you don't have that second limb operating and the reliance being considered in the whole of the context and perhaps equity still stepping in to rescue the plaintiff there. They come to the landing that probably Brennan's view would prevail, and I probably would agree with this. You've got to have some ability for a party to make it clear that nothing that's being said in that big pool of discussions that go on pre-contract will bind them in any way. So that's element 3. Then we have element 4, which is knowledge or intention. And this element kind of links back to element 2 and ensures that the defendant has acted unconscionably. So this element requires that the defendant has to know or intend that the plaintiff will actually go ahead and act on the assumption that the defendant has induced them to rely on. It can be actual knowledge, it can be an actual intention that the plaintiff act on the assumption. It might be constructive knowledge, so the defendant ought to know, or any reasonable party in the defendant's shoes would have known that the plaintiff would act on the assumption. It can include willful blindness, so you can't just encourage the plaintiff to adopt this erroneous assumption and then shut your eyes so that you don't see them going ahead and acting on it, okay? Here we have the case of Ampol and Matthews. The text uses it to explain inducement, but it's also got a nice little snippet in relation to knowledge. What happened there was Ampol was supplying petrol to a company, and the company was ultimately taken over by a company with a similar name, not the same, similar name. The bank account numbers all stayed the same, and Ampol kept supplying their petrol to the new company. The old company did not let Ampol know that it needed to look to the new company for payment of its bills. The old company didn't even revoke a guarantee in relation to its payments. And of course, the supply kept happening. And then ultimately, when Ampol looked to the old company for payment, when the new company didn't pay, the old company said, hang on a minute, there's this new company on the picture here, and we're not responsible. But the court said the failure to notify Ampol and to revoke the guarantee raised an estoppel, and they were bound. So that's the element of knowledge or intent. Nothing really complicated about it. It just shores up the, aspect of equitable estoppel that requires the defendant to act unconscionably. And obviously, you need to have some kind of knowledge in there for that to happen. Element 5 is detriment, and obviously the plaintiff has to suffer some kind of detriment in order to have equity step in and provide the requisite relief. There has to be a link between the assumption that was encouraged by the defendant and the plaintiff's detriment, and the plaintiff actually has to have some kind of material detriment, what they call a material disadvantage, if the defendant was allowed to resign. There are many different forms of detriment that might be suffered, and I guess one of the beauties of equitable estoppel is that it's a creature of equity, so the court can fashion the remedy to offset the nature of the detriment that's been suffered. So that's detriment, and the final, not really superfluous, but tick in the box element is that the defendant didn't act to avoid the plaintiff's detriment, either by fulfilling the assumption or otherwise. So I guess this just leads on from element 5. There has to be detriment under element 5, and the detriments must still be subsisting. That is, the defendant didn't actually go ahead and fix up the problem, make good the assumption, so that the detriment was avoided. Okay, so the detriment is still there and still being suffered by the plaintiff. That's element 6. So that is the case that you need to build for equity to intervene by equitable estoppel. So the last thing we need to get across is remedies. And for those of you that have done equity, you'll recall that there are a number of different maxims that guide the application of equitable principles, one of which is that the relief will be the minimum equity required to do justice between the parties. And that really just ensures that there'll be some sense of proportionality between the detriment that's been suffered on the one hand and the relief that's being fashioned on the other hand. And the case that you need to have a look at here is the Commonwealth of Reliance. And in that case, you had a collision that occurred in 1964 between a couple of armed services ships. One was an air carrier and one was a destroyer. And in that case, there were some survivors that had been injured. However, they did institute proceedings against the Commonwealth in 1964 because at that time there was some High Court dicta that suggested that there was just no duty of care owed between members of the armed services in the course of duty. I guess you can kind of understand why the High Court had made comments to that effect. However, those obiter dicta were overturned by a subsequent High Court case, and so the plaintiffs decided to sue. Now, after they had initiated their action, the Commonwealth made some fairly serious representations over a prolonged period. So the Commonwealth had said that they wouldn't rely on the fact that there was no duty of care between members of the armed services. They also said that they weren't going to rely on the defence that the action would be time barred, because obviously there had been quite a bit of time between 1964 when the injuries were suffered and the early 80s when the action was commenced. Now, the plaintiffs in that case argued a couple of things. They argued that either the Commonwealth had waived its right to rely on those two defences, or that they were stopped from relying on those two defences. And the majority there took a fairly strict view of how remedies should be fashioned by equity in cases such as this. So what the majority did was they said, what's the minimum equity required here? What do we need to fulfil some justice between the parties? And they said, well, we need to think about reliance costs. We're not going to start up here assuming that the representation or the assumption should be held good. No, we're going to look at all the circumstances and ask ourselves, what has it cost the plaintiff in actually relying on the assumption? And that will be the minimum equity that we need to provide. And they said that the reliance costs here had been that the plaintiffs went ahead and instituted litigation, thinking that the Commonwealth would not rely on those two defences. So what they said they could do is they could award the costs of litigation from the time of instituting proceedings up until the Commonwealth notified everybody that it was going to resolve from its previous representations and actually go ahead and rely on those two defences. That amount of money, the cost of litigation for that period of time, will be the minimum equity required for the plaintiff here. That's what we think will give a proportionate remedy. I'm not so sure about that one. See what you think after you've read the text and the case extract. Fairly strict approach to fashioning remedies there. Dean and Dawson in that case took a more perhaps permissive approach, and they said we're going to start from the assumption not that you need to provide only the costs of reliance. You need to step up and you need to say we will work down from the starting point of holding that assumption good. Okay, there is a prima facie entitlement to prevent departure from the assumption. However, if that's going to provide more than the minimum equity, then you can work down from that baseline, that higher baseline. Okay, you can adjust the remedy as required for the circumstances. I think that's probably a more sensible approach, and so did Giumelli and Giumelli, which was a subsequent High Court case. A wonderful little case full of family disputes and all sorts of things, marriage, divorce, subsequent remarriage. It's got a little bit of everything for you, so go ahead and read that case extract. But the High Court essentially approved the minority approach from Commonwealth and Reliance, and they said the starting point is that higher benchmark. You have to make good the assumption unless it's going to provide some kind of disproportionate remedy to the plaintiff. If that's the case, then you can work down from there. You can adjust the remedy and fashion it appropriately down from there. What happened in that case was, I'll cut a long story short, the question was whether a couple of promises should be made good. One was a promise from the family to one of the brothers that the house that the brother had built on some family land, as well as the land that it stood on, would be conveyed to that brother, as well as a lot where he had built an orchard. So he was going to receive some land and the proceeds of being able to run the orchard and live in the house. The court said, yes, we need to fulfil those promises because he went ahead and spent a substantial amount of money in the belief that those promises would be made good. But in this particular circumstance, to convey that land across to that brother would work a fair amount of detriment to his other family members. And in those circumstances, we won't hold those assumptions to be made good. We won't require that property actually be conveyed over. what we will do is we will provide you with the amount of money that you have spent on the house and land in improving it and in building the orchard and improving that land. Now, that sum of money will be given to you along with a security for that amount that would be charged onto that property. So essentially, he got a mortgage over the property, okay? The family would have to pay him that amount, and if they didn't, he could call up that security and demand the payment. So from Giumelli's case, we know that the appropriate starting point is that higher starting point of making the assumption good, and then you just adjust it down as the equity in the particular case demands. So that is the issue of remedies. That is the issue of equitable estoppel. If you have any queries, please don't hesitate to email me, tweet me, send me a message on Facebook. Other than that, I look forward to catching up with you in one of the Zoom tutorials that will be happening soon. And thanks for watching, guys. Bye for now.